Rosa and I are very happy to be here with all of you today. Thanks for joining us for this part two of Who's on the Hook. And we have an action-packed hour ahead of talking about construction accident litigation and insurance coverage issues. They are so intertwined in these types of cases that we could probably do a whole series on this. So maybe we will at some point, but we're going to hopefully give you a really good primer today on the issues that are involved with litigation and insurance coverage. Now, let's just go over a couple of the general sort of ground rules and house rules for these CLEs. There will be a Q&A from 2 to 2:30. We promise to get to all of the questions that we can during that half hour. If you have questions that come up during this first hour of the presentation, please put them in the Q&A. Rosa and I, when we have moments throughout the presentation, we'll take a look. And if we can address some of those questions during the first hour, we're happy to do so. If not, we'll get them in the second half an hour. Also, because there's going to be an overwhelming amount of information that we'll be sharing with you in this hour, don't fret. There's materials that Michelle will put the link to if you didn't get them yet. A lot of what we're talking about will be in the materials, as well as samples you will see, which will help you in your cases. But also, please don't be shy. As Michelle mentioned, Rose and I both offer complimentary one-on-one Zooms to all of you. So the links will show up in the chat, and feel free to schedule one with us or email us. Our information is in our backdrops so that we can help you and answer any follow-up questions that come out. All right. So today we're going to talk about construction accident injuries and the parties involved and the interplay with the litigation and the insurance issues. Because plaintiffs and defendants, and I'm talking about counsel for the plaintiffs and defense, have to know how these insurance issues interplay with each other. Because if you don't have a handle on that, you're not going to be able to resolve your case for your client, whether your client is a contractor, an injured plaintiff, an owner, or otherwise. And fortunately, we have a lot of experience with these cases. We've been litigating, my firm's been litigating construction accident cases for over 50 plus years. And since Rosa brought in the chair and risk division to Smiley and Smiley a few years ago, we've been working with a lot of lawyers and a lot of law firms that have construction accident cases where we will get involved to help them figure it out and sort it out. We will also become a co-counsel on cases. We offer that where we will, what's known as parachute is a phrase where we will get involved in the litigation, usually before motion practice and mediations, so we can help sort out all the players, all the coverage, and try and wrap everything up in a nice bow for resolution, which is what you need to do. So first thing, let's do just a quick little primer on construction accident injury litigation in the state of New York. Now, normally what we talk about applies in states throughout the country. Construction accident litigation is primarily statutory, and it's based on laws in New York State. Now, for a full primer on construction accident injury litigation, you could go to the mentoresq.com or the Mentor ESQ podcast or the Academy's digital library, and you'll find a series I did a few years ago on how to successfully litigate a construction accident case. But I'm going to give a little primer now just so we're all using the same terminology and have a good framework to get into the insurance issues that Rosa is primarily going to take lead on, with me jumping in on the interplay with how it plays out, frankly, in the litigation. So first of all, in a construction accident case, we're looking generally at three statutes under the New York laws. There's labor law statute section 200, which is kind of like common law negligence. We'll leave it at that if you can prove negligence of one of the parties at a construction site. Then you have 241 subdivision 6, which has some strict liability components, some comparative components, but it's another way to get an owner and a general contractor on the hook for an accident at a construction site if you can prove a violation of the industrial code. All right, that's generalization of that statute. The big one that many of us face as plaintiffs, it can help us. As defendants, it can hurt us. But either way, we're talking about section 240 subdivision 1, which is the scaffold law. That's when either someone falls from a height and gets injured, or something falls from a height and strikes somebody and injures them. 240 subdivision 1 of the labor law of New York is a strict liability statute that will apply to the owner of the work site as well as the general contractor of the work site, whether they were even at the work site. All right, it is a strict liability. Now, what happens is that as plaintiffs, you get excited that you may have a 240 subdivision 1 case that you could get strict liability against the owner and maybe the general contractor. But what happens if the owner and general contractor aren't big and they don't have a lot of insurance? Or maybe they have some insurance, but it's not enough for the catastrophic injuries that the plaintiff sustained. Then what happens? Could their business be at risk? Well, they're going to indemnify, which is another term we're talking about. They'll be indemnified by the employer, all right, for the worker perhaps who is injured. But is there enough insurance coverage from the employer if ultimately it's going there? Who is going to end up paying the plaintiff at the end of the day? That is a very simple question, but it's a very difficult question to always answer. And you often don't have that answer until you're at a mediation or you're in the middle of a trial. But you need to know, where is that money going to come from to pay the plaintiff? You need to know that if you're the plaintiff, and you need to know that if you're a defense counsel. Because if you're defense counsel, you don't want it to come from your client's pocket, whether they're insured, whether it's the carrier's money. You want it to come from maybe another party, another tortfeasor, maybe the employer. All right. So what we're going to talk about today is the parties involved, who has what insurance policies, and how we decide who's responsible to pay. Simply as that. So a couple of terms so that we're all on the same page. Owner. The owner is the actual deeded owner of the property where the accident happens. They own the property. Their name is on the deed. General contractor. Sometimes you'll hear that as the construction manager or contractor or GC. The general contractor is the company that is usually hired by the owner of the site to do the work, the construction work, and to oversee all of the construction work. And it's the general contractor that will often hire subcontractors. They may hire a roofer. They may hire an iron worker company. They may hire a carpentry company or an HVAC company, or all the above. So you're going to want to look at the owner and their policies, the general contractor, their policies, and the subcontractors and their policies. Usually the injured plaintiff is a worker who is employed by one of the subcontractors, so you want to look at their policies, or perhaps directly employed by the general contractor. All right. Now, in addition to knowing these players, you have something called indemnification, which is a word we hear a lot about under the law. Basically, what it means is, I don't have to pay for it. They have to pay for it. So what will happen is, at a construction site, the general contractor, if they hire a bunch of subcontractors, 9 times out of 10, there will be a written agreement where they hire the subcontractor and they say, look, you need to indemnify us, which means your insurance needs to cover us if there's an accident involving your crew at the site. All right. And the building owner usually wants to be indemnified from the general contractor. The general contractor, when they're hired by the owner, usually signs a contract saying, owner, if you get sued, we will cover you with our insurance and our defense. But it doesn't always play out so nicely. There's usually litigation. Whether or not that indemnification is going to happen, is it contractual? Is it under common law? What's the priority of insurance coverage? Okay, everybody agrees that the plaintiff was injured and the case is worth $1 million. The owner has $1 million, the general contractor has $1 million in coverage, and the employer has $1 million in coverage. Do they all chip in? Does one pay? How does it work? That's what we're here to talk about today. And it's super important that you learn how to identify these issues, because otherwise you're going to get to a point where you're going to say, I've got a great case. I don't understand. Nobody's paying. You may have insurance coverage issues. You may need to start working on a declaratory judgment action. If you're on the plaintiff side, you want to bring this to a head to get resolution. You can't sit back and let the defense lawyers fight amongst themselves. You want to roll up your sleeves and get in that fight. If you're on the defense side, you want to figure out all the coverage so you know how best to advocate for your client and to transfer that risk loss. All right. So with that being said, I'm now very honored to hand over the floor to Rosa, who's going to get a little deeper into the weeds on how this all works.
All right, I'm gonna apologize up front. Am I choppy? Because if I am, I can switch.
You're pretty good. You're okay, Rosa.
So when I analyze a labor law case, whether it be because we represent the plaintiff, or I represent one of the parties, one of the insureds, or I represent somebody with respect to the coverage issue, I always like to break it down and look at what I call like the anatomy of a labor law case, because it just helps me. I'm a visual person. So I actually put together a little chart, Michelle, if you can pull it up. So before I get into the chart, what I usually do is if I have a state law case, I will go into NICEF, and if I have a federal law case, I will go into PACER. And I will go down and find the most recent and updated pleading, right? And you want to get one that's got all the parties, because sometimes these labor law cases have, it's the defendant, the third-party defendant, the second third-party defendant, the fourth third-party defendant. So you want to get the most recent one. And this is what I do. I pull up the caption and I physically print out the caption. And then what I do is I go through and I identify all of the parties on the caption for myself, saying, okay, this one's the owner, this one's the GC, this is the sub-employer, this one's the HVAC guy, whatever it is, I identify each one of them on the piece of paper. And then what I do is next to the name of every single entity, I'll put primary coverage, umbrella coverage, and I put little blanks. And I leave that for myself so that I can fill that out as the case goes on and as I find out the information, because for anybody who's handling a labor law case, you don't know in the beginning what all the policies are and what all the coverages are, right? So that's a great way to kind of also keep track of what you need to find out in terms of who the players are and what coverage is available for these entities. So what I did was I put together this little chart. Basically, this shows as I said, the anatomy of a labor law case. There's the plaintiff, right? And they are going to sue the owner and the general contractor because, as Andrew said, the owner and general contractor have statutory liability, right? So as a plaintiff, those are the parties that you're going to bring in, and they're statutorily liable if you have a labor law case that falls within the labor law. The owner has a contract with the general contractor, right? So I'm going to call that the prime contract, all right, just to call it that. And then the general contractor obviously has subcontracts with the subcontractors, okay? And for purposes of today, let's just assume that this is the case right here and that the sub is the employer, okay? So now the contract between the owner and the general contractor usually has two important aspects to it. It has the indemnification. So it says, general contractor, you have to defend and indemnify owner, okay? Same thing for the general contractor to the subcontractor. It's going to say, sub, you have to defend and indemnify the contractor and the owner, right? This isn't a perfect world that all of these things are in place. But then that contract also contains insurance procurement language. So what does that mean? That means it says, contractor, you have to get this much coverage for us, $1 million in primary coverage and $5 million in umbrella coverage. And you have to name owner as an additional insured. Okay, so there's two separate things. And I feel like a lot of times people kind of put together indemnification and coverage, and it's two totally separate things. So now the general contractor usually, and again, this is always this is a perfect world, they're going to enter into a subcontract, and that subcontract is going to say, okay, subcontractor, defend and indemnify us, as well as the owner, and get insurance naming us as the general contractor as an additional insured, and you're also going to name the owner as an additional insured. And so basically what happens is the indemnification obligation, so that's what Andrew talked about, indemnification. The indemnification, that runs upstream. Okay, so in other words, the subcontractors, in, again, perfect world, because this doesn't always work out, but the subcontractor is going to owe coverage to the indemnification to the general contractor and the owner. So a lot of times the liability falls down onto the sub, particularly when they're the employer, right? So what generally happens in these cases is that the owner is going to send a tender letter to the general contractor. So let me go over that a little bit. So all a tender letter is it says, hey, general contractor, you owe me defense and indemnification under our contract. So you better pick me up and defend and indemnify me in this case, right? That's what it says. But tenders have a couple of different roles, and it's used differently in two different ways. It's when you're talking about tendering to the contractor, you're tendering defense and indemnification, right? But you should also be tendering to the carrier, the insurance carrier, because you're tendering the defense and indemnification under the insurance policy to the insurance carrier, okay? So I see the mistake all the time where defendants will tender off to each other and they'll just tender to the general contractor, or they'll just tender to the sub. And then the case is going along, and the owner never really tendered directly to the insurance company for the general contractor. And so the insurance company takes the position that, well, you didn't tender. That's what triggers my obligation. So what a tender does is it not only requests defense indemnification under the contract, it's requesting coverage under the policy. And that also serves as a notice by whoever it is, whether it's the owner, the general contractor, that serves as the notice that they want coverage under that policy. Okay, so let's just say general contractor has policy A, right? That's the primary policy. And now owner says, hey, carrier A, I want coverage. A tender triggers their obligation to respond. So we're going to talk about disclaimers of coverage in a bit. That triggers their obligation to disclaim. So if you never tender they never tender the policy, they never tender the coverage, excuse me, to the carrier, technically, the carrier doesn't have to take over their defense. The other important part about that is that, let's just say you represent an owner and for whatever reason, they don't have insurance, which happens quite a bit. That tender starts to trigger the insurance company's obligation to pay the defense costs, right? So if the owner doesn't have any insurance, then they're going to be looking to that carrier A to get defense costs, right? Because that can really mount up defense costs. It also works if the owner has coverage. Let's just say their carrier is Chubb, for example. Chubb doesn't want to pay the defense costs because the owner is supposed to be covered under carrier A, right? They want carrier A to pay the defense costs. And the defense costs are a big part of these cases because the defense costs get pretty large in these labor law cases. Okay, so the tenders are really important. And in that same respect, notice is important from a plaintiff's perspective in these cases, because under New York law in particular, and the insurance law, a plaintiff has a right to place the defendant's carriers on notice, where the defendants don't necessarily have a right to place a carrier on notice for another defendant. It doesn't work like that. The plaintiff has a right because it's statutory. So as a plaintiff, send your letters out. You're not sending tender letters, you're sending notice letters, but send your letters out once you find out who these carriers are. And as soon as the case gets going, and you can get the insurance information, which I'm going to talk about in a second, you can find the information from the certificate of insurance. The certificates of insurance for all these cases, and most of the time, the owners will have a certificates of insurance from the contractor, and the contractor will have it from the subcontractor, and that's really important. And in there, it'll say, if you read those certificates, it'll say, here's the primary coverage for GL, it's carrier this. Here's the umbrella coverage, it's carrier that. notify both of them. And as a
Those are-
plaintiff, you
I'm sorry, I'm gonna jump in quickly. When Rosa's talking about tendering, it's just sending a letter, okay? That's what it is. That's how you tender. You send a letter and basically saying, I'm tendering to you, and that means I want you to take over for us. And we have a sample tender letter in the materials. You'll find it there. So letter writing, tender letters, notice letters are super important. And they're not that hard to do because what you'll learn, if you don't know already, by the end of this hour, is that insurance companies will disclaim claiming they didn't get noticed in time of the accident. They'll disclaim saying they weren't tendered to timely. So you don't want to run into these problems, which will surface after your summary judgment motions, when you're on the eve of trial, you're trying to get the case settled, and you're calling all the defense lawyers, let's talk, what's going on? Like, well, they're waiting on the tender, they're waiting to see whose coverage is, and you're sitting there as the plaintiff saying, oh my God, this is crazy. That's why you need to understand this and get involved early so you're not left with all of these question marks when it's time to resolve the case. Go ahead, Rosa. Sorry
right.
to.
We just had a case, we have a case that we're trying to settle where we found out after depositions, after summary judgment motion, that the defendant, the direct defendant, who had a self-insured retention, so what that means is that they pay a portion of the defense for the case, and they'll
The
pay
deductible.
right, it's like a deductible. We found out after all of this that they never notified the insurance carrier. So we're left fighting with the carrier now for coverage. So that's a whole other, that's not a construction case, but it happens in these cases even more frequently. So last piece of this chart that I just want to point out. So in red, I put the different types of coverages that basically these parties can have, right? So you have the owner who will have a commercial general liability policy and will have an umbrella policy, right? And then you have the general contractor who should have a commercial general liability policy and potentially an umbrella policy. And maybe more than one layer of umbrella, by the way. Depends on, you know, how big these people are and how much coverage they have. And then the subcontractor should have a general liability policy and an umbrella policy potentially. And we're going to talk about 1B coverage in a little bit, which has become very important. So when you're looking at all of these policies, what happens is once the owner tenders to the general contractor, they assign one, they take over. The general contractor's carrier A is going to say, okay, owner, I'm taking over. And now you have one attorney representing the owner and the general contractor. So what we see happen all the time is that when you ask for the insurance disclosure, the defense counsel who's representing the two entities, who was assigned by carrier A, by the way, which is the general contractor's insurance company, they only disclose that policy, right? They'll say, yeah, this is our policy. This is carrier A's policy. They don't disclose the owner's coverage, right? But you have to remember that coverage is still available to satisfy a judgment or satisfy or enter into or participate in settlement of the case, okay? I mean, they're always going to be trying to push down to the subcontractor, but at the end of the day, if there's not enough coverage, they have to pay. And their carriers are going to have to pay, okay? So don't forget about that owner's coverage because it seems to get washed under the rug on every case. Now, the other issue is, look at all of the different, I have them in red there, look at all the different policies, right? So you would say, okay, what policy is in play here? What policies are going to apply here, right? So this becomes a huge part of each one of these cases. And we have experienced as plaintiffs, and I've experienced when I did defense work and carrier work, that a lot of times you're ready to settle this case, you're going through summary judgment, you've had summary judgment, you've won on summary judgment, you're in a mediation, you're trying to settle it, and the carriers are fighting about priority of coverage. Who comes first, who comes second on these cases, right? And even though it technically is not the plaintiff's problem, it is, because at the end of the day, you're the one that's going to, your case is going to get held up. You can't settle the case. And then I find at these mediations, what happens is that the defendants are infighting amongst each other. And this plaintiff sitting back in the, you know, the Zoom room waiting for everybody to come out, and an hour goes by and they're still fighting about who's going to cover what, right? So you would think, like common sense, right, would say, okay, you have the owner and the general contractor have a contract, and the contractor has to provide coverage and to the owner. And a lot of times you'll see the language in those contracts, it says provide primary and non-contributory coverage. I don't know if you've ever seen that language. All that means is that their policies are supposed to be primary, whatever they provide, right? But there's case law all over the place, and I'm not going to get into the details of the case law, but it's all over the place on what is the order that these policies are going to pay, and what's the tower, we call it the tower of coverage, okay? So there's something called, and I'm just saying these phrases because that way if you hear them, at least you'll say, oh yeah, Rosa talked about that, Andrew talked about that. What does that mean again? So there's horizontal exhaustion, and then there's vertical exhaustion, okay? And you'll hear these terms, right? So horizontal means that, usually horizontal means that you're going to exhaust all of the primary policies first, okay? And then you're going to exhaust the excess policies, right? So look at that. That would be the owner's policy, then the GL, then the general contractor, then the subcontractor, right? But there's cases that talk about it a different way, right? And it's called vertical exhaustion, which means the general contractors, commercial general liability, and umbrella have to be exhausted before you ever get to the owner's policy, right? So it just, you can see how complicated it gets and how involved. And the priority of coverage is really determined upon the policy language and what the policies say. But there's cases out there that say the contract rules, right? So the law is all over the place with it. So does the contract rule, it says primary non-contributory, or does the insurance policy, other insurance clause, and that language? So I'm just telling you this so you can kind of get an idea of all the complications that go on these cases. And sometimes, for example, I'll get hired to represent the owner, right, to file a DJ action against the general contractor's carriers, because the owner doesn't want their insurance to be triggered, right? They don't want to claim against their insurance company, against their insurance policy, or against their rating. They don't want it on the books that they paid out. So they'll just hire us specifically just to represent the owner to sue the carriers for the general contractor to make sure that their policies go first.
If you're joining us today via podcast, the first attendance verification code is POD 102. Again, that's POD 102.
Rosa, can I hop in quickly for a second?
Yeah, please do.
So in the materials, you'll have a sample demand from us to use to request the insurance coverage that we're talking about. And if you haven't seen Rosa's lecture on the Comprehensive Insurance Disclosure Act, you'll see the language is tied in with the demands that we gave in the materials. A plaintiff and any party, defendant to co-defendant, everyone's entitled to see all of the potential applicable insurance policies. So you need to get the policies for everybody. And you want to ask for their primary, their excess, if they have more than one excess. And you got to keep asking. And don't just ask for a policy amount. Many times you'll get a disclosure that just responds by saying, yes, insured by Chubb with limits of 1 million or whatever. You have to push back and you have to say, no, I want the whole policy. And under the Comprehensive Insurance Disclosure Act in New York, not only should you get the whole policy, but you should get the claims adjuster's contact information and their name of who's handling the file, so that you can look through all of these policies or get Rosa or another coverage lawyer to assist you in interpreting the policies to figure out, first of all, who has how much coverage, how vertical, what the tower is, and start figuring out these priorities of coverage and how it may play out. And it's not uncommon that Rose and I pick up the phone to another party's counsel in a construction accident case, say, listen, this is what I'm seeing for your coverage. Is that what your understanding is as well? But it says this, this, and that. Do you understand that they have, it appears to be the priority of coverage, or that you have the priority? And oftentimes defense lawyers will be like, I don't know. I have no idea. And so, don't be shy about guiding either your adversary or co-defendant or a cross-claim to get the information you need so that someone figures out who's holding the bag at the end of the day, or at least who's holding the bag first, who's holding it second, and so on. All right, Rosa, back to you.
So now I want to go and take a look at, because I talked a lot about the owner and general contractor, right? And the insurance and interaction relationship. So now let's take a look at the relationship and the insurance with respect to the GC and the subcontractor, okay, and potentially the employer. So everybody knows the plaintiff cannot sue their employer because of the workers' compensation laws, right? So what happens is the general contractor will bring in the employer as a subcontractor. And if you pull up those complaints, they generally have 4 causes of action, right? They for the most part, they assert contribution, common law indemnification, contractual indemnification, and failure to procure insurance. Those are like the 4 standard provisions. A commercial general liability policy doesn't cover the common law claims, okay, against the employer, because there's employee exclusions in those policies. But what happens is, and again, this is all in the perfect world because things have changed over the last few years with a lot of these insurers. Now they have all of these endorsements that eliminate some of these provisions. So you really can't say 100% this is the way it's going to be, but I'm just giving you a general idea. So what happens is the GCs, the subs carrier will provide defense to the employer because there's an exception to the exclusion for an insured contract. So in essence, basically, they're going to defend the subcontractor for the contractual obligation that they have with the GC, okay? But technically, there is no coverage for the common law claims under that policy, okay? So what happens is you usually proceed, and if there's no contract for some odd reason with the sub, then that becomes a problem because you can't bring them in. There's no contract, you can't bring them in. So because there's not going to be coverage. I mean, you could bring them in, but there's not going to be coverage for it. Now, the second part of this, and this is where we're going to explain if you've ever heard of the term 1B coverage. So 1B coverage is insurance. It's called employer liability coverage, okay? And what that is, it's like an arm of workers' compensation coverage, and it covers the common law claims asserted against an employer. All right, so like I said, the general liability covers the contractual claim, and the 1B or employer liability covers the common law claims. However, under the workers' compensation law, and it's workers' compensation law section 11, and we put copies of this in the material so you can take a look at it. This law, it's the law that basically says that an employer will not be liable in contribution or indemnification against, again, the common law causes to any third party, okay, based upon liability for injuries to a worker unless the worker sustained a grave injury. Okay, so this is where that grave injury situation comes into play with coverage, all right? So you'll see grave injury in construction in labor law cases all the time, right? You see motions. Was it a grave injury? Wasn't it a grave injury? But this is how the coverage piece of it pulls in this grave injury, right? So just for purposes of discussion, I'm going to just read off some of them because some of them are clear that it's a grave injury. So death is a grave injury. Then they have loss of fingers, loss of multiple fingers, blindness, deafness, loss of a nose, loss of an ear, loss of an index finger, okay? And then, amputation of a leg, a foot, a hand. The ones that are a little bit more difficult are permanent and severe facial disfigurement, because you could see where you could play with that severe facial disfigurement. And then the other one, which is a very common situation and which we recently had the case, I'm going to have Andrew talk about it in a second, is where there's a traumatic brain injury, right? So it's the way it reads, it's an acquired injury to the brain caused by an external physical force resulting in permanent total disability. Okay. So when that comes into play, you may be able to trigger the 1B coverage. And that's, as I said, that's an important coverage because although there's a dispute about this, and Andrew and I know this is a dispute, they say it's unlimited coverage. So there's a dispute about whether it's really unlimited, but for the purposes of this presentation, let's assume it's unlimited. So you have a really bad case, and now you've got disclaimers all over the place. You don't have enough coverage. You want that 1B carrier involved, right? So Andrew, you want to talk a little bit about how that impacted a case that we were involved in?
Sure. We only have 15 minutes left, so I'm going to try and do this in under 10 minutes and then let you get to the disclaimers and reservation of rights, and then we can get into the Q&A. So here's the scenario. In the materials, you'll see some documents in a case that we have called Tiago Gomez Braga is the plaintiff. And what happened to our client, Tiago, is he was working at the Marriott Marquis. There was a building owner, a group that owned the Marriott. There was a general contractor, and he was brought in by the general contractor working as a sub to do drywall framing work. He's up on a scaffold that's not a very good scaffold, doesn't have the safety requirements, no rails, not tied off, up very high. Falls off a scaffold, hits his back, hits his head, ends up hospitalized for a while, almost a year, all kinds of issues, but primarily the main injury was a traumatic brain injury. All right. And that impacted his ability to work, impacted his physical activities and all of that. So we bring the lawsuit, as the diagram showed, against the owner, the general contractor, and the owner and general contractor had one law firm, and they brought in our client's employer, okay, represented by another law firm. So we have our firm as the plaintiff's firm, one defense firm representing the owner and the GC, and then another defense law firm representing the employer. And sure enough, we get underway, we're moving all the way along, and there's agreements, indemnification, there's different coverage levels. And it turns out when we're looking at all the coverage that the employer only had $1 million of insurance coverage. They had an excess policy of $5 million, but that excess policy disclaimed. They disclaimed because that policy didn't cover the employer for its own employees' injuries. Pretty good disclaimer, pretty bad policy. Most of these insurance policies, you're going to see a lot of them out there now. The employer's policies are disclaiming and not covering injuries to employees. They're basically policies that cover these contractors if a stray pedestrian gets injured, right? But we know it's usually the worker. And the employers buy this coverage thinking they have coverage, and then they realize the only reason they got cheap coverage is because it doesn't cover them for workers. So here you have a situation where the case was worth more than $1 million objectively, and everyone agrees, defense counsel as well as the plaintiffs. And you've got coverage of several million from the owner and the general contractor, but they're saying it shouldn't come from us. It's got to come from the employer. But then the lawyer for the employer says, well, we don't have excess. We just have $1 million. If we get hit at trial for more than the $1 million, and the employer and GC go after us because we indemnified them, we have a contract, our client could get put out of business. They don't have more than $1 million. What are we going to do here? We could be in trouble. So first, Rose and I had to sort out the issue with the general contractor and owner saying, well, the employer, they've got $1 million and they've got excess and they should go fight for that excess. And we're saying, no. We looked at that disclaimer. It's valid. We're not sitting back letting you try and say that it goes to them. You guys are going to have to pony up. We don't care. And then you can go after them. So we're working through all these issues. And as we're getting close to a mediation on the case, the lawyer for the employer that only has the $1 million policy is trying to see if 1B coverage will come into play here because it will help the lawyer's doing a good job to protect his client, the business, the employer. So he's saying they're underinsured. It's my job to get them coverage. So he says, I'm going to try and see if we can get the workers' comp carrier to offer 1B coverage for grave injury. So he looks at all the categories. No, our client's not quadriplegic, paraplegic, didn't lose legs, didn't lose arms, fingers, nose, no scarring, but we're arguing a traumatic brain injury. So the lawyer for the employer is trying to get 1B coverage for traumatic brain injury, but then the workers' comp lawyer says, yeah, but your expert neurologist who evaluated the plaintiff said the plaintiff doesn't have a traumatic brain injury. Sorry. So there's a debate. Maybe the lawyer doesn't want a defense IME saying no traumatic brain injury because then they lose coverage, right? Now, the owner and GC's lawyers wanted to get some coverage from the 1B carrier so their clients didn't have to pay. They'd rather come from the employer's coverage. But the only way they could get the 1B coverage was by arguing a grave injury. They don't want to stand up in front of a jury potentially and say, well, we don't think we did anything wrong, but, and they're not really injured, but yeah, they actually do have a grave injury. They have a traumatic brain injury because they want to resolve the coverage. So it gets really, really tricky. And the way you usually resolve this is by knowing whether or not it really is a grave injury under the law or not, what evidence you have in your case or not. Then you just get everybody to the table. And we ultimately mediated the case. We settled it. 1B said, no, we just don't see this as a grave injury. And so they had to work it out between the owner and the GC and the employer, and they had to all pool all their money together to figure it out. And that's what we did. But on the heels of that, we then parachuted into another litigation to do summary judgment motions on labor law and became co-counsel on a case. And defense counsel for the general contractor and owner calls me up, says, listen, I think maybe we can get at that 1B coverage. And I said, no, you can't get at the 1B because the injuries in this case don't qualify. There's no traumatic brain injury. This person had 8 surgeries on their back and their ankles and all of that, but that's not grave injury. They're not going to give you a dime. I don't want you to delay our case, to delay the mediation, to put off your carrier from coming up with money because you're hoping for 1B. It's not happening. We've done the research. So by me being able to do that and say that, we were able to streamline things leading into the mediation to be successful because we didn't want them all showing up expecting 1B coverage and then there being none and we don't get a resolution. So hopefully that makes a little bit of sense of how this all ultimately plays out. Back to you, Rosa.
So we only have a few minutes, but I wanted to talk about a couple of things. So you're going to see a lot of, in these cases, in these labor law cases, a lot of reservations of rights, and you're going to see disclaimers of coverage all over the place. Right. My recommendation with respect to that is to have them reviewed. There are a lot of what Andrew called those employee injury exclusions, and they're generally called action over exclusions, and there's a bunch of different ones. And some of them exclude coverage for injury to any employee of anyone. Doesn't matter whether it's your employee; it could be any employee. Others have all different parameters on them. They'll say, oh, we're going to cover it, but we're only going to cover it so long as you insured had a subcontract that had a good indemnification and had insurance procurement, and there was actually other coverage, right? So they're basically saying we're not going to cover it unless we're excess, is what they're saying. So there's all different kinds, and you will see those, and I will tell you that those are generally enforceable in New York, okay? But again, you have to look at them and analyze them for ambiguity. What is the language? They're all different. There's no statutory exclusion. They're just different in all of these policies. So you need to read the policy and see what it is and determine whether you think it's ambiguous, it can be challenged or not. With respect to disclaimers, the carrier has an obligation to disclaim once they have sufficient facts to know the basis for the disclaimer. That's the rule, basically, okay? So, for example, if it's late notice, the cases say, late notice from the second you get that notice. So you have, the clock is ticking. You got to disclaim as soon as reasonably possible, right? that's been held to be 30 days, sometimes even less than 30 days. But that 30-day number that you hear all around, that is not a statutory number. The statute does not say 30 days. That is strictly a case law driven number. Okay, so it's not, in stone, it's not definitive. It needs to be proved. The carrier is allowed to have time to investigate a claim and determine whether they have coverage or don't. Okay, so I just want to let people know that. The other document you're going to see is the reservation of rights. Okay,
ROR.
ROR, right. And the reservation of rights does not substitute for a disclaimer. So let's just say that right away, one of the parties gets a reservation of rights, and then they defend the case, and they're defending, and then all of a sudden they're halfway through the case and they're going, okay, now we're going to disclaim. Well, it doesn't work like that. If they knew the basis or had the ability to know the basis for the disclaimer at the beginning, they had to disclaim. So a reservation of rights is not going to cut it.
And it's not a disclaimer, just to be clear. So let's say you represent a plaintiff, you're bringing the lawsuit, and all of a sudden you start getting letters from the carriers for the defendant that say reservation of rights across the top. We're aware of this claim. Coverage may not be applicable. Accordingly, we're going to reserve our rights. Many lawyers will look at that and say, oh, they're disclaiming. That's not a disclaimer. Or some lawyers will say, oh, well, we got that within 30 days. We got it pretty early on. They disclaimed. Doesn't that toll the right to disclaim? No. It's just a reservation of rights. It is not a disclaimer. So you can use a reservation of rights against a late disclaimer. If you get a reservation of rights tomorrow and then they don't disclaim coverage for another year, and since that time, there's been depositions and things going on, you can use that against them.
Yeah, and then one of the things with reservations of rights is that typically the carrier, and this is important for people who have clients that are owners and general contractors, if they have issues with their coverage, typically what they're supposed to do is they issue a reservation of rights on whatever that basis is. And depending upon what's in the reservation, right, because it's very specific, your client as the owner or general contractor may be entitled to independent counsel at the expense of the carrier. So that's something to look at, because if you're defending, let's just say you're defending one of your clients and their carrier issues this reservation of rights, and you're going, wait a second, some of the causes of action are covered and some of them aren't covered. Technically, you're allowed to remain on the case as counsel of choice at the reasonable rate, your reasonable rate, at the expense of the insurance company. And that's something that's important to understand. A lot of times what I see is that the carriers sometimes they disclaim prematurely, because they're afraid they're going to get caught by the late disclaimer. All right. And what happens is sometimes we'll have cases where you have these disclaimers and you realize they really didn't know the basis for disclaimer at the time they disclaimed. They just threw it out there because they were afraid to get caught. And you can understand that, but they're not supposed to do it that way. What they're supposed to do is say, we're not going to cover if this is the case. And then they provide like a provisional or conditional defense. And if they have an issue, they start a DJ action. That's what they're supposed to do, but that doesn't always happen. In fact, it happens, more often than not, it does not happen. But these are things that should be happening and you can look out for. And even if you see all of these disclaimer basis, which we only have 2 minutes, but you'll see things like, there's like height exclusions, right? It's called work height exclusion. So if the employee is on a ladder over 12 feet, there's no coverage. A lot of these exclusions can be challenged, and they're not set in stone. Some of the action over exclusions are pretty set in stone, but some of those other ones are not. I'll finish up my end by just saying that, there's a lot of other exclusions, obviously, that we constantly see, besides the additional insured issues, which we didn't even get to touch upon, and the late notice. And the last thing I'm going to say, one of the questions I get from a lot of my clients who are plaintiffs firms, because we'll do insurance consultation for plaintiffs firms, I get a question about taking defaults and whether or not they should take a default against a defendant. And then when the carrier steps in and says, wait a second, there is a carrier, but there was a late notice situation, and now you have a default, what you're supposed to do with that. And it's a good question, because you probably if it's like a subcontractor that can go out of business, you probably should vacate the default and let the carrier answer, because at the end of the day, there's going to be coverage where the sub can just go out of business and you're not going to get any coverage. If it's an owner, it might be something different because there's an asset. And these are things you need to take into account when you're considering taking defaults against some of these parties, because when the carrier disclaims on late notice, a default is an irrebuttable presumption of prejudice and they won't have to provide the coverage. So you can always call me if you have questions on that one, because I did that one really fast.
Yeah, and I'll follow up on that just as a sort of a practical tip. So it went fast. So in case you missed it, what Rose is talking about is we're often in a situation as plaintiff's counsel where an answer doesn't come in timely. Maybe we send a follow-up letter. If you don't get an answer, we're going to enter a default. And then we enter a default, and then sometimes they show up, you vacate or whatever. The problem is that with regard to disclaimers, that default is a trigger that can protect them. One of the things you have to prove if someone's disclaimer is late, or they're saying they didn't get the information on time and you're trying to argue it was an untimely disclaimer, they're going to argue, well, we're prejudiced because something significant happened in the litigation before we were notified and involved in the case. And that could be a basis for their disclaimer to be upheld and valid. And by filing a default and getting a default judgment, that then gives them the basis to say, yep, you have a default judgment. You had that done before. We're prejudiced. And then they're out of the case. So you got to be real careful. Everyone's always excited. Ooh, let's get a default against the owner of the company. They haven't answered yet. Let's slide it in. The reality is, though, is that it's much easier to resolve a case when there's insurance money than going after a direct defendant. It's really hard. You can't necessarily force businesses to liquidate, to pay for your judgment. It's just not easy. They often don't have assets. They don't have the money. You can't pierce corporate veils. So when you can get coverage, that should be, if you're a plaintiff, your priority. Same thing with defendants. Getting a DJ action or getting a default judgment may not be helpful to you if you're trying to get coverage. So just keep that in mind. The key here is that construction accident litigation is not just winning your construction accident case. If you're a plaintiff, it is winning your case, but making sure that you can get coverage and that you've done the homework. You wouldn't want to settle out a case for much less than it's worth because you haven't availed yourself of the available coverage. That could be malpractice. So don't be reluctant. Don't be hesitant. Make sure you demand all the policies, review them all. If you don't feel comfortable reviewing them, contact us, contact a coverage counsel, but to really represent your client, whether it's a business owner, a carrier, or a plaintiff, effectively and appropriately within our field of what we're supposed to be doing, you need to get these policies. You need to review them. So keep that in mind. There's a lot of questions. This is not easy stuff. There's always something new that comes up just on 1B in and of itself. There's a body of case law of what do you need to establish for it to be a traumatic brain injury under the grave injury law, 1B. It's not easy. Frankly, the person really needs to be kind of like a vegetable. It's not the traumatic brain injury that gives them some memory impairment, cognitive impairment that we see with a lot of our clients. It's a very real, very bad injury. But for it to be a grave injury per the statute, they pretty much can't be able to function in daily living is really what it comes down to. You'll look at the case law and see what it is. So keep that in mind. All right, so we have a bunch of questions. So Rosa, what I'll do is most of them, you're the one that should be answering them. So I'll ask the questions if that sounds good, and then you can take them one at a time and I'll hop in when needed. All right?
Right.
All right. So first question we have is whether or not we're seeing an impact on the plaintiff side as a consequence of these recent RICO and fraud cases. Specifically, are we having to adapt litigation strategy as a result? I believe what the question is referring to is there have been some plaintiffs' firms that have been tied up in some RICO litigation saying that there's fraudulent claims, carriers, there's all kinds of different medical providers involved. I believe what that means. Rosa, have we seen an impact on the plaintiff side from all these cases?
Well, we haven't seen it on the plaintiff side, but I will tell you that since I do policyholder work, I have seen it on the policyholder side, and I have a few clients who were experiencing a really, really tough time. There was constantly these accidents, and they kept saying they're fraudulent, they're fraudulent, they're fraudulent. You know, and it's tough to prove they're fraudulent. And in the last, since that kind of came down, which I don't remember exactly when that was, it was in the last year, obviously. When that came down, things have slowed down significantly for them. I will tell you that. So in that respect, it is an impact.
Yeah, I think the businesses, and they were very frustrated. So our firm, we were retained to represent a builder, and they had all the big builder, and they were getting a lot of lawsuits. And they're saying, we know it's fraudulent. We've got video, we've got things. But when we tell the insurance company, they're saying, oh, well, we don't cover fraudulent accidents, so we're not going to cover you. They're like, wait, so we're trying to do the right thing. And then we tell the lawyer, and the lawyer's like, well, if it's fraud, I'm getting paid by the insurance company. They're not going to cover this. You know, we're not looking into that. So we were hired and we got investigators involved because they needed someone to show that it's not them. They shouldn't be getting hit each time and taking a hit on their policies when there's fraud. So, it really, we are seeing it more on the business side, not as much on the plaintiff side. If you're a plaintiff practitioner, make sure you know who's referring you these cases. Do your own investigation. Just because someone calls you and says, oh yeah, so-and-so was injured at this job site, don't just take it at face value. You have to do your own investigation, because the last thing you want to do is get pulled into some fraudulent accident claim. Okay. All right. Next question. Regarding an owner, what about a situation where an owner is an industrial development agency who has nominal ownership for tax benefits, and the IDA, I guess Industrial Devil Agency, leases the real property back to the company who's actually developing it? So I guess here you're asking if there's a dispute as to who the owner really is.
Yeah, I mean, I don't know the answer to that. That's very, very specific. I don't know.
Yeah, I
Um,
mean,
yeah, I think
you're
it's
gonna have to look into you're gonna have to look at the policies, you're gonna have to look at the facts, the role, their involvement, right? A lot of it is factual based.
and also just, case law wise, what is considered to be ownership or an owner? Because you're right, it's kind of, that's a vague, I mean, I would say owner's a title owner, but maybe there's something in these agreements too. That's the other thing that could make somebody be, deemed an owner when they're not the title owner. So I don't know the answer.
There could
Yeah.
be a litigation just on that issue, right? There could be a DJ action. This doesn't cover because they're not an owner, and this says it doesn't cover owners. And we're saying, well, they are an owner. So you've got to look at a lot of things there.
If you're joining us today via podcast, the second attendance verification code is POD 241. Again, that's POD 241.
All right, next question. Can you explain the difference between a general contractor and a construction manager? My understanding is it's just words. You look at what their role is at the site. So general contractors may not say, hey, we're the general contractor on the site. They may say, we're the construction manager, or we're overseeing it. So you really need to look at the role. Rosa, unless you have other thoughts, what we've generally seen is when there's a construction manager and you don't see any other entity that appears to be performing the role of a general contractor. So in other words, you have an owner, you have another company they're calling the construction manager. That company has a huge contract with the owner. They're overseeing safety. They're overseeing all the subcontracts. They're the ones contracting with the subcontractors. They have the site safety superintendents at the site. They're going to be deemed, in essence, the general contractor under the law. Right, Rosa?
Yeah, I agree with
All
that.
right. All right. Next one. How do you tender to the carrier when you don't have the carrier information and the GC won't forward your letter to the carrier and won't give you the information? Is it sufficient if your tender to the GC includes an instruction to forward it to the GC's carrier? So maybe if all you have is the lawyer for the business, is that a valid tender, Rosa, if you tender it to their counsel?
It's not going to be as to the insurance company, but again, if you can't find out who the insurance company is, then your notice to them is only going to be as soon as you can reasonably notify them. If you don't know it, you don't know it. Now, what I would say is if there's a lawyer involved, right? If you're sending a letter to the GC's lawyer, I would demand that they forward it to the carrier. and that they disclose the carrier. If you're in litigation, they have to give you the name of the carrier. If you're not in litigation, that's when you get into this issue, I think. But once you have that, you're in litigation, the Insurance Disclosure Act is going to require them to disclose that to you. And, you can subpoena the certificates of insurance and all that too. So that's how you can get the carriers as well.
Yep. So remember, you need to cover all your bases. So if you don't have something like, well, I know the lawyer, send a letter to the lawyer, put it all in there saying we're hereby demanding that you forward this to all applicable insurance companies for this matter, because then that defense counsel, if I'm defense counsel and I get a letter like that, I'm not going to throw it in the file. I'm going to notify and try and find everybody, because then if the defense counsel doesn't do it, then guess what? You just got another policy up in a case that may have to contribute. And we have a case like that right now. It's not construction accident, but the third party administrator for a defendant failed to timely notify the carrier. And we finally agreed to mediate, and the carrier showed up, the third party administrator showed up, and the defendant showed up. And they're all putting together packages because the third party administrator dropped the ball here. So, you can get other coverage there. You just have to do your job of papering this to death. All right. Question: can you demand the policies for the subcontractors?
I don't see that question, but
Yep.
yes. Once everybody's in the case, everybody is required to give you the insurance, whether you have a direct claim against them or not. So,
Yep.
yeah.
Sorry, I think I jumped ahead. All right.
I see that Ed Hayes mentioned that construction managers can be liable, which is what you were saying, Andrew, if they have the ability to control, right?
Yep. Thank you, Edward. And you put in a site for that as well. That's what you're going to want to look at, the facts, circumstance. If they say, well, we didn't have a GC, we had a construction manager. Be like, well, let's see what the construction manager did. All right. Chris is asking, what is the deadline to tender? If the tender's late, does insurance company have to prove prejudice to decline coverage? Is there a good faith requirement? Can you go to the Department of Insurance if the tender is ignored by the carrier?
Okay, so the Department of Insurance, I personally don't find that they really get involved, especially if there's litigation. They're not going to get involved with it. So I don't know the answer to that part, except that I wouldn't think they really would do very much, or it would really matter. You can complain, you can file a complaint against the carrier. Now, about the deadline to tender. As soon as you can get that information, you're supposed to tender it, right? So an insured needs to tender as soon as they know that they're sued. They should know who their own insurance company is. And if they don't, they need to call the broker and say, who's my insurance company? The plaintiff is the one that gets into a situation where they can't find out who the carrier is, but the defendant should know. Now, about the late tender, the rule is Insurance Law 3420 says if the notice is within 2 years, then the carrier has to prove that they were prejudiced. If the notice, which is the tender is a notice, if the notice is more than 2 years, then the insured bears the burden of proving the prejudice. Okay, and it's material prejudice, like it impairs their ability to defend the case. Very difficult to prove, very difficult. But again, if there's a default, that's an irrebuttable presumption of prejudice. So that's the rule. And if you look at Insurance Law 3420, it says it right in the statute. It says it outlines the requirements.
Great. All right. Another question: for a tender to be effective, does it have to be to the notice address in the policy, or can it be to the carrier's headquarters or some other address like Secretary of State or Department of Insurance? Great question.
Okay. Secretary of State or Department of Insurance are not going to accept service of, in my experience, of that kind of thing. They're only going to accept service of pleadings. So Secretary, I don't believe that notice to the Secretary of State or the Department of State is going to do anything with respect to that. Can it be to an address other than the notice on the insurance policy? I mean, I don't know why not. I mean, half the time you don't even have the insurance policy. I know we do that all the time. We did it probably 3 or 4 times this week, where we had to go online, find out the address for the insurance company and where to serve them with a tender letter. That's what it was. And we just went online and we tried to find the claims address. And you can always find an address, and you can always find an email address. And we send certified, first class mail, and email. And it seems to get their attention.
You got to do it. You got to do it with some form of tracking. You need proof, obviously. All right, Jason. Hey, Jason, good to see you are here. And your question is, do we have a right to find out if the defendants have a declaratory judgment action against each other? Can I ask for this in CDs, in the CDs, I guess in the disclosures, in
Oh,
your demands, combined demands? Yeah, I would imagine that's what it is. Can you ask?
yeah,
Why not?
definitely. You can
Yep.
demand that. And
Yep.
a lot of times I find that it's difficult to find the DJs when they're in federal court and state court. You could find it because you're just going to put in the name of the insured, but in a NICEF. But in federal court, I find it very difficult to search that kind of stuff. So yeah, I definitely would ask for it.
And pick up the phone. I think a lot of us stand behind our emails and our letters. Rosa and I have been very proactive. We'll send an email to defense counsel on a case, even if there's two, three, or four defense firms. Say, hey, are you guys free? We'd love to just Zoom and touch base on this case. And most lawyers will do it, or at least try, or get on the phone. And then we'll get everyone together and we'll say, look, what's going on? Have you guys sorted out coverage amongst each other? Are there any DJ actions? And you might hear one say, well, we're thinking about it. We're not sure. Well, what are you thinking about? And who's handling it? Are you going to do your own DJ? Do you have DJ counsel? What's your position? So just work the phone sometimes and just call as much as a plaintiff, we want to get the scoop what's going on with all the defendants. The defendants want to be nice to the plaintiff because at the end of the day, we can help. We can say, all right, we're not going to point our guns at you because you don't have the policy and you're working to get their money up. So you're working to get money up for the plaintiff. So you don't have to pay it. We'll point the guns where the money is. So, you need to have these conversations. It'll make the litigation go a lot better. All right. Hey, Patricia, can you briefly discuss how frequently counsel should follow up for aggregate impairment? And I'll ask you to explain what Patricia's talking about. What is aggregate impairment?
So just so that the audience knows, Patricia is my coverage partner at Smiley. So, okay. So one of the things that happens is that in New York, the policies can be impaired. So what happens is, let's just say it's 100, 300, a 1 million, 3 million policy. Okay. 1 million per accident, 3 million per occurrence. And now there's 3 accidents. All right. And they've paid out $2 million, or they paid out $2 million. How much is left or whatever? So the policies can be impaired. Okay. They can be less than what the whole thing would be. So for example, let me give a better example than the one I gave. If they paid out and there's been multiple losses, and now there's only a tiny bit left on the policy, right? Let's say it's $50,000 left. You're never going to know that. So part of the Insurance Disclosure Act requires or allows you to request information on the impairment. So you're allowed to know that. You want to know that, right? We just did that on the case that I had mediation on Monday. We said, has it been impaired? Has the policy been impaired? Because a lot of times also there's an impairment because the policy gets eroded by defense costs, and you just don't know what kind of policy it's going to be. So she's asking, how frequently should you follow up? I mean, look, it's tough to constantly be on it like that. It is a great idea to do it. Certainly, I would certainly, in the beginning you want it, and under, the law, once you file the note of issue, you may want to say, well, what's the status now? And, again, if you're ready for trial, what's the status now? I mean, obviously, the more frequently you do it, the better.
Yeah. Yep. And also, if, we've talked in other lectures about sending bad faith letters. So you would want to put in your bad faith letter, if you send it at some point, it's our understanding that you have $1 million of coverage, but because you've gotten the policies and you've read them, you see in the policy that it says, out of this policy will be a self-insured retention first, or a deductible, or this policy is going to be paying for all expenses, all litigation costs, all attorneys' defense costs. It comes out of that. You're sending that bad faith letter and saying, well, we see you have $1 million, but it's an eroding policy, or we'd like to know to what extent, if any, it's been impaired. And that triggers their obligation to respond to you and say, yeah, well, it was $1 million policy, but now it's down to 915,000 available. And you want to know this. So as Rosa said, at significant events in the litigation is always an appropriate time to ask. I'd ask when discovery is complete. I would ask if you're working on your mediation papers with a mediation coming up. You know, I always have a section in my papers, which I recommend that you all do before mediation. Practice tip here, exchange your mediation papers with your adversary. Don't just do it to the mediator because you want the adversary, the lawyer, to share it with the carrier. Everyone should know your position coming in. And one of the things that we always put in our mediation memorandums in advance is what we believe the coverage is. General counsel, general contractor is this company. They have a layer of this primary, 2 million. They have excess of 5 million. Subcontractor, this is what their coverage is, who the companies are. So you know who that is. And you want to be able to put in there. They had 1 million policy. It's now eroded. They're going to be, we anticipate a lot more litigation ahead. And if they continue at this, they're going to erode so much so that their client is going to be improperly covered, not have enough coverage. So keep an eye on it.
One more thing I want to say on that, just because I had a case that was pretty significant with it. What the carriers did, there was multiple accidents and there was, only so much coverage. So what they did was they called in just the plaintiffs that they wanted and they settled those cases right out from under the other people. And the law in New York is that they can do that. It's first come, first serve. That's the law.
All right.
As far as I know.
So Robert's asking about what the deal is with 1B coverage, and is it unlimited, not unlimited?
Okay.
Give it a shot, Rosa.
I'm going to give you my quick answer to that. What I've been told is that it's limited to the extent of the coverage of the amount of coverage above. Okay, so in other words, if the GC's got $3 million, then it's limited to, because let me explain it this way. The GC technically is seeking indemnification, right, through this 1B policy. So if the GC is liable to the tune of 3 million, then technically all they're going to pay is 3 million. That's my understanding of it. But yeah, you ask other people and they say it's unlimited. And I think probably people who are, who work for the state fund would probably have a better answer to that. But that is my understanding of what the situation is that it's limited to the coverage above it.
Yeah, and we've tried to find out, Robert, in our cases, and there's a lot of coy responses. Well, they have, so if we had a situation where the owner of the building and the GC had multiple layers of coverage of $10 million, but they're like, look, we have indemnification, then the 1B carrier, we're being told, well, the most we'd ever be exposed to is 10 million because that's the most coverage they have. Whether that plays out, and the reality is that most of these cases will resolve. If the 1B carrier is really going to be on the hook, they're going to put money in, and usually everybody throws some money into the pot. I've tried to find it. I don't, someone help me out here and post something if you've seen an actual litigation to determine grave injury during a construction accident where there's parties all litigating, how it all plays out and who's responsible. We haven't seen it because we usually get summary judgment and then it's a matter of who's paying what and we sort it out. But that's the key. You got to get all the parties to the table. Otherwise, you can leave it to where nobody knows what's going on. The worst thing you want to do is try a case that no one's sure of where you're going. And then at the end of the day, you may not even be sure who's responsible to pay the verdict. All right. And then he's following up, Robert, saying when the owner slash contractor brings in the sub for 1B, do they have to specifically plead 1B grave injury?
I've never seen that.
Yeah.
I've never seen it, but doesn't mean they don't have to do it. But in the ones that we've had, it wasn't pled.
Yeah, I haven't seen it actually pled. And it's also tricky because if you're going to plead this is a 1B case, then you don't want to necessarily put down anything that can, if you're a defendant, say we're acknowledging it's a grave injury. You could plead in the alternative if it is deemed, then, but yeah, coverage usually isn't part of pleadings. So, all right. Does 1B kick in only if there's coverage from either an owner or GC? Put another way, if there's no coverage from the owner or GC or the employer, but there is workers' compensation and it's a grave injury, is there 1B coverage available?
This is what we were just talking about. I'm not sure. I'm not sure because technically, I mean, I would think so, but that would be my gut that I would think that there would be coverage because it's an it's an employer liability policy and it's covering common law liability. And but again, I really would like to see the answer. I'd like to know more about this myself because it is very interesting and I just don't know the answer to that.
Another question, does new information developed in the lawsuit reset the clock for a carrier to disclaim?
Yes, but it depends on what it is. So
What the information is.
something that they could have found out, they can't just say, "Oh, I just found it out now." If they could have determined it earlier, then they should have determined it earlier and disclaimed earlier.
All right. We're getting close, so let's try and get through a few. We have about 3 minutes left. Again, if we haven't been able to get to your question, just reach out to me and or Rosa directly. We're happy to meet with you and see what we can do to help. A fast and easy one. What's the deadline to file declaratory judgment action? Is there a statute of limitations on that?
Not per se. Again, what I'm going to say is if you're a plaintiff, an insured, it's a contractual breach. So if you're going to file a DJ action, it's a 6-year statute of limitations in New York. All right. So that I will say, but, a lot of times the carriers are filing their own DJ saying we want out of coverage. And I don't know what, maybe it would be 6 years. I don't know because the other way around, I'm not sure. But from the perspective of the insured, I know it's a 6-year statute because it's a breach of contract claim.
Okay. All right, let's make this the last one. There's a couple of multiples within this. This is from Selena. Can plaintiffs send out a notice letter after a carrier disclaimed? Should plaintiffs put all parties on notice, and is there a time limit to do that? What if the GC didn't bring in the sub and employer? What is the recourse? How can a DJ action be helpful for a plaintiff's attorney? What should it include? So there's a lot in there.
Okay. So, yes, a plaintiff can send out a notice after a carrier is disclaimed, but kind of at that point, the carrier is disclaimed. So it just depends on the basis of it. I'd have to see it, okay? Because you do, as a plaintiff, you do have an independent right to place them on notice, all right? Now, should plaintiffs put all parties on notice, and is there a time limit to do that? Again, it's just as soon as possible. There's no time limit. But again, the more you delay, they're going to claim late notice or prejudice from the delay. And let's see, what if the GC didn't bring in the sub? What's the recourse? All right. How can a DJ action be helpful to a plaintiff's attorney? All right. So plaintiff's attorneys are limited in their DJ ability under the law. So there's only certain circumstances in which a plaintiff can bring a DJ. And there are certain circumstances. We just brought a DJ in one of our cases because we had a disclaimer. So there are certain circumstances. There are other circumstances where you cannot, but there are some things that you can do to get other parties to file DJ. So if you want to reach out to me, we can talk about that a little bit more because that's a really detailed question.
Yeah, just thanks again, everyone. It's always great having you here. We're really happy to have this community that we can share what we know, what we don't know, and we can all share with each other and help learn more and grow our abilities within this profession. Feel free to reach out to us if we can help. Next month, we're going to be talking about litigation issues with premise liability cases, and it's going to be exciting.